Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on the deletion of the addition made by the assessing officer under section 69 just on the basis of statement of the assessee which is later on retracted. The issue before the Chennai ITAT A bench was that if some assessee gives some statement that he has given some loan to another party in a search and later on retract that statement, so whether in the absence of any evidence, clinching evidence that the amount has travelled from A to B and without verifying or without summoning the borrower, the addition for cash loan to the other party can be made under section 69. This issue has been taken up by Chennai ITAT A bench in the case of Deputy Commissioner of Income Tax versus Sujai, Anand, Reddy. This case is reported in 127 ITR Tribunal, short notes 22, and the date of the judgment is 19th August 2025. In the present case, the assessment year is 1920 and the assessment of the assessee was completed under section 153A. There was a search on the assessee, and in that search the assessee got his statement recorded, and in that statement the assessee made some statement that the assessee has given a loan of rupees 1 crore to some party VF, and some loose sheets and some electronic devices were also found at the premises of the assessee, and another loose sheet titled as VF payment details were seized from the residence of K. When the assessment proceedings were going on, the assessee denied the statement and said that the assessee has not given any loan or cash loan to any party. But the assessing officer, without verifying the borrower, who was VF in the present case, made the addition just on the basis of the statement recorded of the assessee during the search proceedings. When the matter came before the CIT appeal deleted the addition on the basis that without any clinching evidence or without any solid evidence or without conclusively establishing that the assessee has given some cash loan to another, the addition under section 69 cannot be made. The revenue filed appeal before the tribunal, and when the matter was before the honorable tribunal, the tribunal was of the view that the outlaw of cash did not appear in the loose sheet in the present case but was only known in the sworn statement which was later on retracted. The tribunal said that there is no evidence that the cash loan has been given to party VF and the addition cannot be made on the basis of unverified and contradictory evidence. The tribunal said that in the present case it is an undisputed fact that the statement of the assessee is unsubstantiated. The tribunal said that there is no evidence which is legally sustainable in the present case because there is a contradiction regarding the evidence, whether this evidence is from the electronic device or whether it is in the physical form. So it cannot be said that the evidence is authentic. The tribunal said that in the present case the most important factor is that the assessing officer has grossly failed in verifying from the borrower, which is VF, and no summons has been issued to the borrower. So without cross-examination, without any corroboration from the third party, without summoning the third party, the addition on the basis of the statement which is unverified, which is denied by the assessee during the assessment proceedings, the assessment is and the addition is bad in law under section 69. The tribunal was of the considered view that for section 69 it is the duty of the assessing officer to conclusively establish that the assessee has made an investment. If the assessing officer fails in his duty to establish that the assessee has really made some investment, then the addition cannot be sustained on the basis of presumptions and assumptions just on the basis of the statement recorded during the search proceedings which has been conclusively and denied by the assessee in the assessment proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Sujai, Anand, Reddy, and this case is reported in 127 ITR Tribunal Short Notes 22, and the date of the judgment is 19th August 2025. Thank you, friends.